Martinez?
Yes.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
And are we going on count one only?
That's my understanding, Your Honor.
Give me a second to get a phone. All right, Mr. Martinez, in cause number 25, DCCR 1414, the state has elected to proceed on the count one only. It alleges you committed the second-degree felony offense of aggravated assault with a deadly weapon from August 10th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes, sir.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Padgett?
Yes, sir.
Do you fully understand them?
Yes, sir.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, sir.
And it looks like the agreement is for a 6-year deferred probation. There would be a $1,000 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, sir.
State tenders number 1.
No objections to states 1, Your Honor.
It's admitted. Is there any evidence that Mr. Martinez is not competent?
None, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation before you leave the courtroom today, and she's sitting at that desk right over there.
Yes, sir.
All right, we'll see you back at sentencing.
May I be excused, Your Honor?
Mr. Garrick, we called your name this morning. You weren't here. What happens when you're not here on time is your bond gets forfeited and there's a warrant for your arrest. It's very important that you get here on time.
Yes, ma'am. I kept in contact with the bond people while I was on the way here.
Okay.
Entirely.
Okay. So I'm going to recall that bond forfeiture. And this is your initial appearance, Mr. Garrick, in cause number 26 DCCR 0961. You are charged with the second-degree felony offense of assault on a peace officer from March 12th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, ma'am. But I also have been having situations like since me being locked up, it stopped a lot of like money problems, So it kind of like was an
Are
issue.
you working?
Yes, ma'am. Right. Currently, I start my job this week, but
So here's what I'm going to do, Mr. Garrick. Now, once you bond out, I expect you to at least try to hire your own lawyer.
Yes,
So I'm going to reset your case for about 30 days to give you some time just to see if you can get someone hired.
yes, ma'am.
If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer and they'll tell you what you need to do.
Yes, ma'am.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. Do you understand? All right, step in front of the clerk. She'll give you a reset notice. It's obviously it will now be probably the oldest case on my docket, so it's very likely that it would be number 1, and we'll know that on the pretrial date.
And my request would be, again, I know this is an unusual request, but obviously it's very expensive and time consuming to come in for a pretrial. So my request would be to just note, I don't know that there will be any pretrial issues other than getting trial order. So if he could appear via Zoom or appear, let me appear on his behalf or something like that for pretrial. And again, normally I don't ask for special dispensation, but he's a Haitian refugee. He's not a loaded with money person, and it takes a lot of energy and effort and costs and days of his life to come here and then go back. And so
and I will do my best on that. Obviously the concern, isn't just about him either. So it is going to have a pretrial. Miss Malfino, if you'll get with Mr. Katina and whoever is going to take care of that case, we'll put it on the trial docket. And if you will just send over some request in writing, a memo or something to myself, Mr. Katina, and Miss Malfino, so that I will remember that when it gets a little closer to that pretrial. And then I wouldn't think there would be any objection. Okay, so we'll allow him, unless something comes up that obviously we need him here for some pretrial hearing, we can do that by Zoom for him. Okay?
I appreciate it. Thank you.
I'll walk out of here before I do that.
At this point, the case shifts from determining guilt to gathering information that could influence sentencing. Many viewers wonder why someone who has already pleaded guilty is not sentenced immediately. The answer is that the court often orders a pre-sentence investigation so probation officers can prepare a detailed report about the defendant's background, circumstances, and other legally relevant information before sentencing. That report helps the judge make a more informed decision instead of relying only on the facts presented during the plea hearing. Emotionally, this is often where reality begins to sink in for a defendant because the case moves beyond admissions and toward long-term consequences. What do you think? Should judges always review a full pre-sentence report before imposing punishment, or should sentencing happen immediately after a guilty plea? Let's return to the courtroom as the judge explains the next required steps.
How do you plead that charge?
Plead guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them, that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Paget?
Yes, ma'am.
Do you fully understand them?
I have to go through them again.
You want
So-
copies of them, but.
Sure. Is there anything about those documents that you signed that you know right now that you don't understand? So do you understand that if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. You understand? Also, and it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenors number 1.
No objections to states 1, Your Honor.
It's admitted. Is there any evidence that Mr. Jacks is not competent?
None, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. So the underlying, it looks like there was a protected party of a Lillian Ortiz, which is the issue underlying. I want to make sure you understand, Mr. Jack, that as of now, a condition of your bond, if it wasn't already, it should have been, is that you have no contact or communication with Lillian Ortiz. Do you understand?
Yes, ma'am.
Do y'all have children together?
Yeah.
Okay.
Yes, ma'am.
Yes, ma'am.
So any switch of children or talking about children needs to go through a third party, a parent, a brother, a sister, or through the family court with attorneys. All right. Does that make sense? So you can't go in person, pick up and drop off kids. You need to have someone do that for you.
Yes, ma'am.
That is very important. You can't call, you can't text. You need to have someone else do that for you. There's also some great programs and apps that you can get on your phone. One's called the Family Wizard. I would be absolutely encouraging of you to do that. Y'all both get that app, and every communication you have is saved on that app. So she can't say he was doing all this or he said blah, blah, blah. And you then can talk about kids have a doctor's appointment or kids have a soccer game or whatever it is. But it has to be an approved app, and you can talk to probation about that when they do that pre-sentence report.
Okay.
Make sense?
Yes.
All right.
Good thing is they worked all that out. There has been they have no reason to contact each other. The way
Perfect.
things are set up now. So,
Sounds good.
but I appreciate the admonishment.
All right. So talk to stop and talk to probation on your way out of the courtroom today. She'll get that process started for the PSI, and we'll see you back at sentencing.
Yeah.
All right. Free to go, sir.
Thank
Thank you.
you.
This hearing demonstrates how criminal courts carefully separate a guilty plea from the final sentencing decision. Rather than imposing punishment immediately, the judge accepted the plea, confirmed that it was made knowingly and voluntarily, and then ordered a pre-sentence investigation before making a final sentencing determination. That process reflects the court's responsibility to consider more than just the offense itself before deciding an appropriate outcome. Throughout these proceedings, the judge consistently emphasized following legal procedure while ensuring that every defendant understood the consequences of the decisions being made in court. It serves as a reminder that accountability in the courtroom involves both due process and judicial discretion. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.